you so much for that kind introduction. And good morning, everyone. Is it still off? Oh, here, I'll speak this. We got a lot of mics up here. That works. We'll start here. Speak. All right. So we are here to follow up on Mr. Howard's presentation with a spirited discussion of the public policies and the constitutional law implicated by the widespread phenomenon of collective bargaining in public schools. Teacher unions, in particular, have stepped up in the public attention in recent years. For example, they're commonly found in the conversation about critical race theory in public schools. Usually this takes one of two forms. The first form, as illustrated by American Federation of Teachers' Randy Weingarten, is to assert that, quote, let's be clear, critical race theory is not taught in elementary schools or high schools. The other form is to assert that critical race theory is happening, and anyway, it's good. Here is the other national union's current resolution. The National Education Association believes that in order to achieve racial and social justice, educators must acknowledge the existence of white supremacy culture as a primary root cause of institutional racism, structural racism, and white privilege. The NEA also recently spent its members' money on a report to, quote, research the organizations attacking educators doing anti-racist work, unquote, including the Federalist Society. So, welcome. These are vivid examples, of course, but are they illustrative of broader policy implications? What are the effects of widespread unionization of public school teachers? And in general, do teacher unions advance or hinder the core purpose of public schools to give students a quality education? And finally, what should we think about teacher union power and the political process? That last question has policy overtones, of course, but it also raises some constitutional questions, some of which you heard about from Philip Howard. This panel is going to drill deeper into them. For example, does the Constitution's guarantee of a Republican form of government to the states restrict state and local governments from bargaining collectively with public employee unions? Do public employees' fiduciary duties to the public interest conflict with collective bargaining or political organizing? And would or should courts do something about these issues? Here to discuss them are my four esteemed panelists. Dr. Michael Hartney is a fellow at Stanford University's Hoover Institution, an adjunct fellow at the Manhattan Institute, and an associate professor of political science at Boston College. His work on American politics and public policy has been published in top academic journals and features in major media outlets such as The Economist, New York Times, Washington Post, and Wall Street Journal. Dr. Hartney's first book, How Policies Make Interest Groups, Governments, Unions, and American Education, was published late last year by the University of Chicago Press. It examines the origins, power, and activities of America's teacher unions and shows how governments have long subsidized the unions' political organizing efforts, enabling them to wield outsized influence in American education. Eric Stahlfeld has been Chief Litigation Counsel and head of the legal team since 2018 for the Freedom Foundation, whose self-described mission is to free public sector employees from union bondage. Eric graduated in 1992 from the Marshall Wythe School of Law at the College of William & Mary in Virginia, after which he moved to Washington State to practice law. Prior to law school, Eric worked in the Office of Presidential Personnel under President Ronald Reagan. I haven't even gotten to you yet, Elia, so you're doing great. David Osborne is, oh yes, I learned from the master. David Osborne is Senior Fellow for Labor Policy with the Commonwealth Foundation and of counsel to Goldstein Law Partners. In his roles as CEO of Americans for Fair Treatment and founding President and General Counsel of the Fairness Center, he has advocated and litigated for teachers, firefighters, and other public employees mistreated by union officials, supporting those employees in exercising their First Amendment rights, and practicing in federal and state courts and before the National Labor Relations Board and various state labor boards. Especially relevant for today is some of his work with AFFT, where he helped charter school teachers successfully decertify a National Education Association affiliate and custodial workers replace an AFL-CIO affiliate with their own independent union. Ilya Shapiro is a senior fellow and director of constitutional studies at the Manhattan Institute. Previously, he was executive director and senior lecturer at the Georgetown Center for the Constitution, and before that, a vice president of the Cato Institute, director of Cato's Robert A. Levy Center for Constitutional Studies, and publisher of the Cato Supreme Court Review. Ilya is the author of Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court. He's a prolific writer in academic, popular, and professional journals, including the Wall Street Journal, the Harvard Journal of Law and Public Policy, and just a lot more. He even appeared on the Colbert Report, I believe back when Stephen Colbert was funny. Shapiro has testified many times before Congress and state legislatures and has filed more than 500 amicus briefs in the Supreme Court. He lectures regularly on behalf of the Federalist Society. Without any further ado, turn it over to you, Dr. Harding.
Thank you. It's great to be here. I don't usually speak to an audience of attorneys predominantly, hang out with political scientists, social scientists, crunch a lot of numbers, so this is a nice change of pace for me. And in that spirit, I'd kind of like to begin with a question and ask just a show of hands, how many of you, not counting my panelists up here, are familiar with an attorney by the name of Bob Channon? Bob Channon. Okay. So I think this is an interesting place to begin, and I'll start with sort of a pretty provocative take, which is, if you asked me who I would put on the Mount Rushmore of American education, if we think back, say, for 150 years, who has had the most influence on American education and who because of their work today, continues to have influence, even though this person is retired, I would say Bob Channon. For those of you who don't know, Channon was, for about 40 years, the chief legal counsel for the nation's largest public sector union, the National Education Association. Now, why would I claim that someone like Channon has more influence in American education than folks like Dewey, William Sanders, who discovered teacher value added, the list goes on. And the reason begins with timing. So Robert Channon went to work for the NEA in the late 1960s, fully a couple of decades before our nation really got serious about education reform, when we had the 1983 A Nation at Risk report. And the reason that matters is that Channon single-handedly basically brought these laws that Philip was talking about previously to the states, at least the laws that pertain to teacher collective bargaining. And in the process of writing my book, I discovered that Channon, along with a fellow council member from his law firm, wrote sort of a treatise for people trying to pass these laws across the states, these labor laws. And what was interesting to me was, despite the fact that most of the time when we think about collective bargaining, we think about salaries, bread and butter issues, is government getting too big? If you look at what Channon said to sort of the field organizers that were in the vanguard of getting these laws passed, he said the most important thing for you to do is to get strong association rights into these contracts and to get state politicians to enact provisions that will help sustain our organizations politically. So before they even turn to bread and butter issues, Channon essentially was saying we want subsidies in collective bargaining agreements and in state labor laws. What do I mean by subsidies? My book argues that the reason that teachers' unions have such outsized influence in American education is because they're politically powerful. But they're politically powerful not because they work harder than other interest groups, they have a more moral or compelling case about what they want to see the nation's education system look like. No, the reason that they're effective, Channon himself said this in what we might here in Washington call a Kinsley gaffe. He said that the reason we're powerful is that we have millions of members who pay us dues money. And so it starts with the dues money, it starts with labor laws that until Janus made it very easy for teachers' unions to be able to convince even teachers who didn't want to be members to contribute money to the unions. But it also goes to a lot of other things that we are less familiar with that I argue play a very important role in sustaining union power. So for example, in a lot of collective bargaining contracts, you'll actually find language where the school district, the government employer, guarantees to pick up the salary, or the taxpayer pay the salary of the local teachers union president, right? And so obviously this local president is not spending all of their time hashing out a collective bargaining agreement. Some of the time they're spending on politics. So in essence, the government, the taxpayer, is subsidizing this particular interest group. It goes to a lot of other areas. In my research, I came across contracts where the union had negotiated to get the school district's mail system to stop at union headquarters and pick up any of the literature that the union wanted to distribute to teachers, take it to the schools, and put it in teacher mailboxes. Okay, so we could go through lots of different examples of this. Perhaps my favorite one comes from the state of Alabama, where the longtime executive director of the state's NEA affiliate, who coincidentally was the Democratic nominee for governor in the 1990s, Paul Hubbard. In the 80s, he convinced the state legislature to enact a law that required every school district in the state of Alabama to deduct automatically a PAC contribution from every member of the state's Teachers Association and forward it right on through the district's payroll office. Again, sort of a subsidy here because the employer is doing the work of helping organize. So I want you to think about that here in a year where we're in the 40th year of the anniversary of A Nation at Risk. Think about, we made strides in the education reform movement, but reform groups don't have those same benefits. If you want to start a parents' rights organization or you want to help a charter school advocacy organization, there's no one providing you with a list of contact information. There's no one helping you collect your dues. Even the Parent-Teacher Association, which is hardly another Goliath. In fact, oftentimes they work hand in hand with the teachers union. A couple of years ago, tried to raise their dues by $1. The motion failed because they were afraid they would lose too many members. During the same time period, if you look at what NEA's dues were, they rose over $150 at the national level, and the organization did not lose any members. So I think one of the things that we have to think long and hard about is really going into these labor laws and saying, you know, this isn't even really a conservative case, it's sort of a fairness case, and saying, you have a right to exist, you have a right to be an advocacy organization, but we're not going to pump you up on steroids and do it at the taxpayer's expense. So I think that's the first thing that we really need to think about here. What's been the result of this? Well, we heard a little bit earlier, or there was a question, I think, about school boards. What's their role in this? I'm afraid I have to agree with Philip, and you know, I think I was telling him last night at dinner that his solution's kind of the home run, the walk-off home run approach here. It would be great if we could get that done. There's probably some smaller ball things that could be done, but one of the first things we need to think a little bit about are our school boards. You know, research done by Terry Moe and myself has shown that for the last 25 years, when the teachers' unions make an endorsement in a school board election, they win 7 out of every 10 times. And what's more, that winning success rate happens in both conservative Republican parts of the country and in liberal parts of the country, in part because these elections are often held at odd times of the year. The candidates don't run with labels. There's not a lot of competition. So we need to think a little bit about that. I want to conclude by taking up sort of the Steelman case, though, here for what do unions bring to the table. So if Randy Weingarten were here, she would probably say a lot about, well, first thing she always says is that teachers want what students need. And I'll return to that in a minute and provide you some evidence that that's actually not the case, at least when it comes to union behavior. But she'd also talk a lot about, and the unions do, their role in defending so-called workplace democracy. But I think they really need to be held to account on that issue, because if we examine the record, they themselves do not appear to really be practicing what they preach. As I said a moment ago, the unions continue to defend low turnout school board elections. Efforts to make school board elections coincide with November federal elections have often been opposed by teachers' unions because the research shows that they win about 10 percentage points more of the time when those elections are held at odd times of the year. Another thing I would point out is that many of these, and I think Philip points this out in his book, a lot of teachers today played no role whatsoever in electing their union into power, because the way that labor law operates in these state public sector bargaining laws is that once a majority of teachers have voted to recognize a particular union and ask them to bargain on their behalf, that victory entitles them in perpetuity, that union, to represent all those teachers. The lone example here that contradicts this was the case of Scott Walker in Wisconsin. So one of the reasons the unions were so upset at him was that he said, look, just like Congress has to run every 2 years on the House side, unions, you need to go to your members and say, and get a show of faith that over 50% of them want you to represent them. That's something I think that we should do more of. I think, as I understand it, Governor DeSantis recently got a law enacted in Florida. I think it's that if a union's can't show 50% membership in a district, that it would trigger a recertification election. So that's something to explore. But again, there's a lot of evidence here that unions are not really practicing what they preach on democracy. We can also talk about, I think some of the other panelists will talk about opt-out windows. They make it very hard for you to leave the union. And also on representative advocacy. 30, 40% of teachers are Republicans, but obviously 95% of the union money in political advocacy goes to Democrats. So even on the notion of whether they're in the vanguard of defending workers' rights and democracy, that doesn't hold up. Let me conclude by saying something I just said a minute ago I wanted to share about this question in regard to do teachers' unions advocate for what students' needs? Now, I'm not going to say there are never any cases where advocating for more education spending is a bad thing. There are some studies that show in places and at time periods where fiscal investments have been low, that an injection of funds, particularly for low-income kids, can be a good thing. But let me give you this example. I just wrapped up a study looking at 2,500 school board elections in California. And I had information on which of the candidates were endorsed by the union and which were opposed. And I looked at a question that Ronald Reagan asked many years ago, which was, are you better off than you were 4 years ago? I looked at whether, rather than how voters responded to that question in school districts, how teachers' unions responded. How did they respond when considering whether to endorse incumbent school board members seeking re-election? If Randy Weingarten is correct, and teachers advocate for what students need, you would expect teachers' unions to have endorsed the re-election efforts of incumbents who presided over school districts that had a growth in student achievement. At the end of the day, that's what we care most about, hopefully. But that's not what the evidence showed. In fact, I found that regardless of what student academic outcome measure you looked at, the unions were no more or less likely to endorse incumbents even if they had significantly improved the state of the schools for students during their tenure. The only factor that I could find any statistical evidence for driving union support was whether senior, and I note senior teachers, were rewarded with salary increases in the year directly before the election. So they're just like the rest of us. What have you done for me lately? But that's more pernicious than sort of common sense suggests, because research shows that after about 5 years, teacher effectiveness plateaus. There's no guarantee that simply having more experience makes you a better teacher. And yet, because we know that more senior teachers tend to be more active in their unions, it was not surprising to see that the union's endorsement electioneering activity was driven by responsiveness, not just to what's good for all teachers, but what's good for the teachers that are most active in their union. So I'll pause there.
All right, thank you. All right, over to you, Eric.
Thanks. I'm going to throw out a hypothetical that I think the issue primarily is with judges. Excuse me. And certainly it's on the Ninth Circuit, which is primarily where the foundation has litigated. We were founded in Olympia, Washington. We've expanded to Oregon, California, with litigation in those states. We since have expanded our efforts to help public sector employees get out of public sector unions across the country, but so far we haven't really brought any lawsuits specifically on that. We've got, I know the Fairness Center just argued a case yesterday in Pennsylvania with us. We've got some New York cases going on. We're looking at Minnesota as well. And we've done an amicus brief for a person who tried to get out of a union when the union forged the person's signature to join the union in the first place. We're still waiting for the Eighth Circuit to try to figure out how that might be constitutional or not constitutional. But I'd like to just mention something Mr. Howard said. I don't remember what case it was, but he said unions are typically on the same side. The judges don't believe that. I think it was our Belgao case where the court actually said because the unions typically are on the other side of the bargaining table and they have a combative relationship with the various governments, that's a justification for ruling against an employee in that case. If anybody really cares about that, I'll go back and find the specific case. But the judges don't believe unions are bad. They simply believe unions are good. And until we can convince the judges otherwise, we're going to not succeed in any litigation. We're not going to get the case to the U.S. Supreme Court, I don't think, without a lot of preparation for that. The Janus case was the culmination, and 3 or 4 other cases. Abood was the first one, which said you can have public sector employees, but in the course of that, you can compel the employees or people who don't want to join a union to pay only for bargaining over wages, hours, and working conditions, not political aspects. We had several other cases between that. Knox, Harris versus Quinn in 2014 was the first one, which said for partial government employees, home care providers, whatever, that nothing the union was doing for those people in fact was anything but political, and therefore if somebody wanted to leave the union, instead of paying 90% of the dues or 80%, or some unions actually say they spend 30% of their money received on politics. So if you didn't belong to the union, you only had to pay 70% of the full dues. Harris versus Quinn said you had to pay 0 dues because literally everything those unions were doing was political. Janus came along 4 years later and said that doesn't apply just to partial government employees, but to all government employees in the states. Everything they do is political. If you're going to try to figure out, I think Janice mentioned the school districts. If you're going to try to figure out, and I think it's in the book as well, what should be the structure of a school? Should it be teacher performance? Should it be education? Should it be some sort of merit system? All of that is inherently a political decision, and if the unions try to argue for one of these as being better than others, that's a political decision, and we cannot compel a person to either join the union and agree to that argument, nor can we make them pay dues to support that if they disagree with whatever the position the union is taking on that. And so Janus said, if you want to leave a union, or I'm sorry, well actually Mark Janus had never actually joined the union. So for those people who have never joined a union, they can't be compelled to pay anything. Since then, I'm aware of one case in any federal court in the entire United States which has said that actually applies, and we're going to hold a government accountable. We're going to say it was a judge, Judge Mossman in Oregon, now senior judge, who said, I'm granting a preliminary injunction against the government taking dues from somebody who had not consented. Other than that, every single case we can think of, or we're aware of, I know Fairness Center, and there's any number of other organizations like us. We all talk with each other, we write amicus briefs, et cetera. So far, not one other federal judge at any level has said Janus actually applies. I'm going to go through what all those lists are. But we've tried getting the U.S. Supreme Court to take the cases. And the court has not expressed an interest in that. So if we, as a practical matter, are going to try to get this ruling, I strongly suggest we not do it in California, Oregon, or Washington. Because just by way of example, we had, and we're going to file a cert petition early next month, we have 5 cases where the unions forged the signature of a person. Again, Janus started off by saying you have, in the initial situation, the exclusive bargaining representative, the concept that once you take a government job, by the nature of your job description, you must be represented by a union who has the right to speak to negotiate with your employer over your wages, hours, working conditions. Obviously, you have given up that right. That's a constitutional issue. So far, the court hasn't been willing to say that that's unconstitutional altogether. But the starting point is the Constitution applies. The court takes a look and says there is a constitutional right at the beginning. Janice says when the money goes from the union, from your employer, that's your lawfully earned wages, your property, and the employer gives it to the union, that is, again, a constitutional issue. It's a compelled speech question. So on those cases, Janice in between said, how do I get from the one constitutional issue to the end constitutional issue? And Janice talked about consent. That is, you have a constitutional right not to pay the dues. You have to consent to have the union take your money. There's been a whole lot of litigation over that, but obviously when you never consented, you never joined the union, just like Mark Janice never joined. When the union forges signatures, and we've got over a dozen cases where we have made that case, or that argument, and brought it in Washington, Oregon, and California, all cases. But on the Ninth Circuit, we just lost 5 cases, memorandum opinions, which is just no real argument. But it's interesting to me because we had a Judge Nixon, or President Nixon appointed Judge Wallace. We had Judge O'Scanlan on the panel, and all 3 basically said, this is not a constitutional problem. When we have those kinds of judges on the Ninth Circuit, it's going to be very hard for us to prevail in a court system there. Happy to talk about that more if we've got questions. Let me just go through what the Freedom Foundation does in terms of helping people get out of public sector unions. It's a 2-step process. Typically, first we have to know who the public employees are, so we can submit public records requests. We also like to talk to employees before they get to the union. Typical process is when you're hired, you have a new employee orientation by your government. We would like to know, because the unions get to those and they typically sign the people up. Sometimes the people don't even know that they're joining a union at that point. But California, for example, has a law which prohibits anybody except the union from knowing when the new employee orientations are. Again, what obstruction is there? I don't think, when we looked at that law, I don't think there's actually any legislative history. I don't know who proposed it in the sense of did the unions push it. They so own the California legislature that it just got passed without any serious discussion. Secondly, in Janus, once we find out who the people are, we reach out to them, mail, email, phone calling. We have canvassers who actually will go to people's homes in states, and however it is that the people try to get out of the union. Unions, again, put many roadblocks in the way. So we lawyers litigate over those roadblocks. Not just us. The foundation has over 50 cases right now. We've brought over 70 cases on Janus trying to help people get out of public sector unions. The courts have a number of explanations for why Janus doesn't apply. First of all, we have in the Ninth Circuit at least 2 panels, memorandum opinion, who said there is no constitutional right to disassociate from a union. That is, Mark Janus had never joined. The concept basically, who came up with the phrase uncivil obedience? Somebody did, and that's essentially what the Ninth Circuit liberal judges are doing is, well, unions are private entities. The Constitution doesn't apply to private entities. So heaven forbid that the Constitution would apply to a union. This is just like a bridge club. Once you join the bridge club, there's no constitutional right to get out. Okay. So we have, in talking with people who try to get out, we have cases where people never signed. Well, the union typical response to Janus, and this started after Harris versus Quinn, Rebecca Friedrich's case 2 years before ended up with a 4-4 split after Justice Scalia passed away. Unions knew what was coming down the pike, so they would typically try to go to employees and say, would you please sign this card? There's all kinds of cases where the employee would sign some sort of card. One of the first ones that was decided by a appellate judge panel was Melissa Belgau in Washington State, our case, where the union, where the panel looked at it and said, well, what are you actually arguing? And our argument was the card that Melissa Belgau signed said clearly that I agree to continue to pay dues for 1 year, notwithstanding whether I'm still a member. That's typical. Most people don't bother reading it, quite frankly. It's actually generally pretty clear that is in many of the cards that people sign. But the argument there was when you're waiving a constitutional right, Miranda warnings, you plead guilty to something, lawyers probably know there's a whole laundry list of constitutional rights to confront your accusers, to appeal, jury of your peers, et cetera, you waive. The usual standard for waiving a constitutional right is voluntary informed consent. You have to know you have a right not to do it. You have to be told about that. In the Belgau case, the Ninth Circuit said, well, no, this is just a contract, and so you really don't, you've got a contract to join, and so you don't need to actually have any constitutional standard on that. But still, so there's a card. So we brought cases subsequent to that where there is no card. The union just simply didn't ever get somebody to sign a card. Everyone had thought that Janus changed the system from an opt-out system to an opt-in system. That is, you could automatically make someone pay dues without any agreement or anything else like that. If you need consent, then that's different. The union has to actually get consent before they start charging dues. That is, the employee has to opt into union membership. Well, the Ninth Circuit thus far has said even when there is no card whatsoever, there's no evidence whatsoever, Janus somehow doesn't apply. And if people want, I'm happy to talk about what the theory is behind that. We have the forging signatures. These people, which I mentioned before, these people have obviously never joined a union. They're like Mark Janus. The consent is obviously lacking. The unions typically continue to take dues even after we've gone to them and said, hey, wait a minute, you've got no consent from this person. She's never or he's never signed a card. The unions typically will make us file a lawsuit, and then they will typically then say, well, oops, sorry, we made a mistake. Here's some money back. The case is, you're no longer being forced to take dues. There's no prospective relief, no real money damages here. The courts, Ninth Circuit, essentially argued that what we were claiming was not a constitutional violation for taking the dues and giving it to the union, not even so much the unions telling the state to do this, which in the vast majority of states, Washington, Oregon, California, all have laws which say the government, which is running the payroll deduction system, has to take the word of the union, whether or not the union has consent. They said what we're really complaining about was a misuse of state law, of that state law. And we're complaining about a forgery, and a forgery is not a constitutional violation. Therefore, there's no Janus violation whatsoever. We have other cases, you talk about all the roadblocks they put in. Unions refuse to provide cards, so we have no idea. If there's an opt-out window on a card, typically it says, on my anniversary date. I don't know how many people would have any idea what an anniversary date is. I mean, I know when I was married, August 10th, but if I'm signing one of these cards, I don't get to keep the card. Typically, it means the date I signed this card, and typically there will be a window, 2 weeks or maybe a month before the anniversary date. But no public employee, especially not somebody who signed a card 3, 4, 5 years ago, knows when that window period is. So we started off in Oregon. The unions refused to give us the card. It was a 2-week window, so every Monday for almost a year, we had about a dozen people who were trying to get out, and we just simply sent the same opt-out on behalf of these people until the unions finally let them out. Since then, they've learned that we're actually tough on that sort of thing, so they at least will tell us, when the window is, even if they don't provide the card. We have a lot of people who signed cards that have no language. I mentioned that the Belgao was, I agree to pay dues even if I'm not a member. Some people signed cards back in 97, 93 that contained no such language. Typically it would be a dues deduction card. So there's no equivalent concept there. But again, if you join the union, agree to have dues paid, if there's no right to get out of a union, then they can keep you in as a union member. And if they keep you in as a union member, no court out there is going to say you can be a union member but not have to pay dues to the union. We have
Eric, we may want to keep more for the Q&A section.
Q&A
as well.
session, okay. So we then have a whole bunch of other concepts. Some cards refer to collective bargaining agreement. Is there state action when the union and the government collude in the CBA to say you have to stay in until the end of the CBA? Some of the CBAs go for more than 4 years. Michigan, the unions, when Michigan went to right to work, quickly entered into 10-year CBA agreements that said you've got to follow these rules for 10 years. That, again, doesn't seem to be a constitutional violation. Experience. I know New Jersey was mentioned in the book. We actually hired somebody not quite a year ago. So we have one person who's working part-time in New Jersey, part-time in New York. We have actually had a fair number of success. I'd just like to throw out how difficult it's been and then what the numbers are as a result. We were very fortunate in that we did a public records request to the New Jersey Department of Education, which gave us a list of 80,000 teachers, not the classified employees, but just the teachers. The unions weren't aware that they should fight us over that. Sometimes we have to go 5 years before we can actually get a list. We got it very quickly. We then did mail, emails to those teachers. The information we got, the Sunlight Policy Center in New Jersey actually has got a lot of information about the teachers, so we can craft a message to the teachers. A typical mail piece would be this. It's basically a flyer like this. It contains a BRE on the back saying, hey, to us, authorizing the foundation to go ahead and forward their opt-out message to the NJEA. This one primarily says New Jersey union dues are the highest of any of the teachers in any of the other states. People can talk to us. We have one person who gets to talk to them. His comment when I talked to him about it was, first of all, most employees in New Jersey do not believe they have a right to leave the union. So as a starting point, if people don't believe they have a right, it's a question of how do we go out and talk to those people and say you have a right. When you talk to the union on their behalf, the phrase was, the door to crazy opens, because the unions will say anything, do anything. They're absolutely nuts about this sort of stuff. But eventually, when we can show the union that we actually know what we're talking about, we get the card, the unions typically stand down. We had about 50 people across not just the teacher unions, but across all unions. We've been averaging, since the beginning of this year, around 50 opt-outs a month. The last 3 months, because we've finally focused on the teachers, we're around 180 people who are opting out with a month with one person. That's tiny for the whole state, but once people start learning that they can get out, they don't have to pay anything in dues. Yeah, I think, and we're hopeful, that we will be able to at least reach maybe, what is it, the 30-35% of union members who actually disagree with the union political spending and all that sort of stuff. And that will have a huge impact on the union's ability to funnel money into New Jersey. And one of my pet things is New Jersey, if they don't have to worry about spending on campaigns in that state, the NEA is very effective at funneling money from one state into other states. And that, to me, is a potential target for legislation, certainly in various states. Some states don't allow any union dues to be spent on political activity. Some do. Federal government doesn't allow union dues to be spent on federal elections. So there's some possibility of pushing that way.
Wonderful. Thank you, Eric. David.
Thanks, Jonathan. One thing didn't make my bio. It's a recent development. There's a charter school in Jacksonville, Florida, that was kind enough to entrust me with a group of 9th grade students. It's a class called American Civics and Discourse. I hope that they're watching now, and there will be a test. So I'd like to suggest that we have certain tools in the existing law that, if used correctly and if improved upon, could really reintroduce some accountability for those running the country's largest unions. For time's sake, I'm going to focus on just one, and I'll also propose some small, realistic tweaks that would make it more effective. I've got a lot more where this came from. So let's back up. In 2017, the city of Erie began negotiations over a new collective bargaining agreement, covering a relatively small group of employees that worked within the waterworks division of the city of Erie. Erie's population had been falling for decades. In the 1960s, it was something like 140,000. And by 2018, it was less than 100,000, dropping it fourth on the list of Pennsylvania's most populous states, behind Philadelphia, Pittsburgh, and then Allentown, the city about which Billy Joel sang, "It's getting very hard to stay." So Erie had a very sensible idea that they would move their employees from a defined benefit pension plan to a defined contribution plan. But of course, they had a difficulty that's been well described today. They had a collective bargaining agreement that covered pensions. And they'd have to convince employees represented by AFSCME, one of the country's largest labor unions, that the move would be in their best interest. AFSCME, by the way, has a statewide policy, probably a strategic position nationally, that is very clear, but not necessarily shared by members, certainly not shared by taxpayers, that they would never, ever give in to defined contribution retirement plans. Never. They figured that if they gave in somewhere, then they'd have to give in everywhere. So here's what the city did. It was strategic. It presented two options. Option one included a 3% wage increase and a new retirement benefit that some of the employees had been asking for. But it would move the employees to a 401k style plan. It's actually called a 457B. And then they give them a second option. Option two included a smaller wage increase, no new retirement benefit, and it kept the existing pension plan. The city's intent was that the union would present these two options to the employees, and the employees would make the correct decision for more benefits, higher wages, and moving to a new defined contribution plan. Now, the city membership, they correctly, so I say that the correct decision would have been for employees to move to the defined contribution plan, because I eventually met a majority of these employees. And they told me that they loved this option and would have voted for option number one. But they also told me that they never heard about option number one because the union never told them about it. When AFSCME took the final offer to membership, it presented only option number two with the defined benefit pension plan and did not tell employees about option one. when employees in the ratification meeting asked about option number 1, the union told them that it wasn't offered, and that rejecting option 2 would result in a worse offer or even layoffs. In other words, the union misrepresented the offer from the beginning in an effort to induce ratification of the contract, ultimately forcing a worse deal on the employees just because AFSCME wanted to maintain a really hard line on publicly funded pensions. Employees eventually voted for option number 2. Okay, now there is an existing remedy in the law that's available to employees in this situation, but it's poorly understood. I think it's underutilized, and it really needs to be improved. Unions, public sector and private sector, have a legal duty called the duty of fair representation. This is sort of like a fiduciary duty that union officers owe to the employees that they're supposed to represent. They have to treat employees fairly, in good faith, and without discrimination. So duty of fair representation claim is available today to most public employees, either in court or through their state labor board. And they aren't exactly rare, but they're utilized for a slim kind of situation, usually around the employee losing their job and the employee and the union failing to come to their aid. But duty of fair representation claims can be filed for every aspect of union misconduct, from misspending members' money to hostile treatment of non-members or even minority groups. It still happens. To situations like this, where the union executives put their own public policy interests above that of the employees. I was lead counsel for this group of Erie public employees who ended up winning not only a judgment, but entitlement to damages. We won on the merits and then proceeded to a damages phase, and the union and employees settled on an amount. But the net effect of this, as Philip Howard has proposed, would hold the union accountable, at least for these employees, for having abandoned its purpose as representative for a select group of unionized employees and taken on the responsibility of social engineering. So I propose that the duty of fair representation is one means of holding union executives accountable. There are others: decertification. There are recertification laws, and we mentioned Florida and Wisconsin. Iowa has one. The executive branch could unilaterally withdraw recognition if it had bravery from some of these unions, but it doesn't do it. And there's something called the status quo obligation. Status quo obligation requires employers to observe an expired contract, even after it's lived out its life. That's a function of the duty of fair representation, of fair dealing. So I'm happy to share some other reform ideas to make these sort of more realistic options. But for now, I'll turn it over to the panel and our fine contributor, Ilya.
All right, thank you, David. Ilya, take it away.
Thanks for having me. Sorry I was late arriving. We had an emergency collective bargaining issue arise with the youngest members of my local this morning. We were complaining about the conditions of breakfast that we had to arbitrate with an external moderator, ultimately appealing to the Supreme Court, and she resolved the matter, and it was all good. But I was stuck in traffic crossing the River Styx over to the district. I no longer have an office here, so I'm unused to the rush hour, and so I'm most apologetic that I missed Philip's remarks. So if what I'm about to say about the legal analysis in the Supreme Court is repetitive, at least that means great minds think alike. But I do apologize in advance if I'm about to just regurgitate some of his key points, because I think his book, which I imagine his remarks this morning were a summary of, is fantastic. And I think lays out a lot of the meta-legal problems with public sector unions. That is, the unions bargaining with the government. It's kind of like two wolves and a sheep arguing over what's for dinner, right? The taxpayer doesn't have the citizen, the parent, the forgotten man doesn't have a seat at the table. Well, what do we do about that? With my vast expertise in education policy, given my run for school board 2 years ago in Falls Church, I won in that I don't have to serve on school board. So The chairwoman of the board is our next door neighbor. She still won't talk to me. The vice chair, however, I play tennis with regularly, so it's soft power, right? Anyway, look, if we're talking about, I was asked to talk about how the Supreme Court would take a look at these challenges. And the thing is, it's not going to be an overnight thing. The court hasn't even taken any of these cases that my colleagues have discussed about exclusive representation and other post-Janus follow-ons. So they're clearly not primed yet, nowhere near to be primed yet for a head-on challenge to the constitutionality of public sector unions or some of the benefits they enjoy under current labor law. It's a fertile field that will need to be plowed and sown and all the rest of it if, 20 years from now, we can achieve what Janus finally did in overturning the Abood regime of 40 years. That was a precedent from 40 years earlier. But what Philip goes into, I think is correct, whether you approach it as a guarantee clause. I don't know, the guarantee clause really hasn't been litigated. The court tends to see challenges like that as more of a political question. At the state level, the guarantee clause equivalents have been somewhat more successful. I know my friends at the Goldwater Institute have litigated various things about what taxpayers having to pay for union activities and release time and all these other things under their state constitution. So I would commend state constitutional challenges be brought in all sorts of places. But federally, Janus and its progeny and what we've mostly been talking about is under the First Amendment, and that has its limitations. You're not going to take down a structural regime based on the First Amendment entirely. That does, as Philip put it in his book, the First Amendment doesn't get at the corruption of the conflict of interest, the evident conflict of interest of, say, Governor John Corzine of New Jersey at a rally saying, "I will fight for a fair contract." Wait, you're the government. They're negotiating with you, so obvious conflict there. But the basic constitutional issues are how sovereign power is undermined, and this is my favorite chapter of the book. It's chapter, I'll refer everyone to section 3, chapter, I don't even know what chapter it is, the first part of section 3, where he talks about public bargaining disempowers elected executives, the people that the citizens elect are locked into all sorts of pre-existing contracts and structures that they can't reform, even if that's the policy that people want. Public sector bargaining preempts vital legislative responsibilities because it creates a powerful preference for union interests over other public interests, kind of an equal protection problem. When there's a bargaining impasse, unelected arbiters are making legislative choices, so there's a delegation of legislative power. Non-delegation is before the court in a different context this year. There definitely can be non-delegation issues of giving authority over policy making, over legislation, lawmaking to these third parties, whether it's arbitrators or whether it's the unions themselves. And sovereign authority is corroded by organized political activity by public unions. Some of that my fellow panelists have talked about, where taxpayers are in effect funding political activity, and it's kind of a vicious cycle. The erosion of presidential power at the federal level with federal public sector unions is perhaps the most direct thing, I think, that can be challenged, the shortest runway to effective litigation, because as I've been learning, I've been asked about this with various working groups and things. The idea that, for example, there are collective bargaining agreements that last longer than a presidential term. And so various policy priorities simply cannot be implemented because personnel is policy, and if you can't reform personnel, you're locked into pre-existing systems and structures. That's a real appointments clause problem. It's a removal power problem. It's definitely a very tangible Article 2 thing before you have to kind of think creatively about how to make claims, colorable claims under the guarantee clause. And those kinds of claims have resonated with the court in recent years. There's yet another case before the court involving the structure of the CFPB and its funding mechanisms this term, as well as administrative law judges in the SEC. So, you know, if you can make claims, if you can consider challenges that are most akin to ones that already have been brought successfully under appointments clause and removal and now appropriations clause, those I think have resonance and can have bite. But the longer term thing about you know, operationalizing as a legal matter FDR's qualms about public sector unions and that obvious conflict, it'll take some time and some really creative lawyering, but I hope I've issue spotted that enough. I think it's most important, this public sector issue, in the educational context, because I think COVID revealed that educational freedom and opportunity is the civil rights issue of our time, and so ripe for all sorts of odd bedfellow coalitions and messaging that you know, can resonate in the legal space as much as in partisan politics. Thanks.
All right. So I've exercised moderator's prerogative, ask a couple questions of y'all, and then I want to get to your questions as well. Ilya, I want to take things up right where you left off, where when it comes to operationalizing the guarantee clause, how it seems as if these questions at the state level of delegation or privatization of sovereign power, whether you characterize it as legislative or executive, this seems to be a question at core of like state separation of powers. Do you see a way, even if it's got to be, you know, a long march, 10, 20, whatever years from now, how do you see that working? Do you think it's ultimately tenable to read the guarantee clause as some kind of one, justiciable, two, like mechanism to enforce or you know, shape up the state separation of powers?
Well, I mean, the state separation of powers are done under their own constitutions. At the federal level, what's resonated in terms of separation of powers type challenges is administrative law, right? The court's about to rework, if not completely throw out Chevron this term. They've been, you know, the major questions doctrine is nothing if not saying, hey, you can't just you know, give this big chunk of power and defer then to, you know, in this case it would be unions or a CBA that's not negotiated at arm's length or what have you. I think there are ways to couch these things without having to run on unbroken ground. You know, running on unbroken, unplowed ground can have its advantages. See the Second Amendment litigation, you know, Heller and McDonald and Bruin now, where you could make it up because there was just nothing done and it was ripe, and there was the personnel was finally in the courts that saw things that way. But there are advantages to you know, running the same playbook that we've had success on, as I said, the removal and appointment and all of those things, but also seeing how some of these things can be read as major questions or problems with over-deference or non-delegation in some other hydraulic forces way, as Justice Gorsuch has put it in other contexts.
Mm-hmm. David, I wanted to ask you another biography item I omitted for time was your, I believe, two-time service on the federal impasses panel in the federal sector when it comes to the public unions there. Do you see it being plausible that one could argue that federal unions or arbitrators in the federal space are in some way intruding on or attempting to exercise as non-elected entities executive power in ways that could, I mean, the issues that jump out at me would be, and Ilya talked about this some as well, potentially violating the executive vesting clause, the appointments clause, private non-delegation. So curious for your thoughts on that.
Sure. The Federal Service Impasses Panel is a poorly understood entity within the federal government. I was appointed in part of the Trump administration. What we were supposed to do was decide disputes between federal agencies and the unions that represent their employees once it comes to an impasse. And I should add, we tried to impose a long-term collective bargaining agreement that would have outlast President Biden. Sorry. We did try that because the agency presented some evidence that negotiations are very costly for them, and that having to go back to the bargaining table every 3 to 5 years and sometimes bargain to impasse, that's the reason they were in front of us, is extremely costly. So we gave them a very long term, just to demonstrate that this is not an equal playing field. Once President Biden got into office, he very quickly reached agreement with unions to reopen all of these contracts that we had long-term expiration terms on. That means that only, in this case, a Republican administration, only the Republican administration can lose. When the Democrats are on the side of the unions, they will always win because they're working together. Okay? So the questions about arbitrators in the system, arbitrators end up deciding some very important issues and end up restricting collective bargaining agreements. They are outside of the purview of the federal government in the sense that the government cannot abridge what the arbitrators laid down. It's sort of a zero-sum game. And yeah, absolutely. I think there's a strong argument that in constructing a system like this, in which ultimately the president, who's supposed to be running our government, is unable to effectively manage his own workforce, we've got a serious problem, and a problem that, yeah, should be corrected through litigation. Good question, Jonathan.
But you were a presidential appointee, right?
That's right. Yep.
Excellent.
Jonathan,
Yeah,
I didn't
please.
fully answer your previous question, I'm now realizing, because you were asking about a federal court backstop to what states are doing to reinforce state separation of powers. And I think there could be something there akin to what the court just decided in terms of state election regulation in the Harper case, where the majority put in place, oddly enough, the Rehnquist concurrence in Bush v. Gore, and saying that state courts still employ judicial review of state election law, subject to ordinary principles of judicial review. So they effectively can't go on frolic and detour and go crazy. There might be something like that here as well, in the sense that whether it's framed under the guarantee clause or due process on kind of a Caperton corruption type thing, or something else, there could be a federal court backstop if the federal courts are interpreting clear state laws to prevent conflicts and other things, gift clauses and what have you. Could be. It's a high bar.
Certainly, my instinct as a lawyer is when I hear guarantee clause, my mind immediately goes to political question.
Right.
Was it, I think, Doors Rebellion, I think was the issue in Rhode Island, but that you had basically rival, I guess, legislative slates. It wasn't like the Spartans had invaded Rhode Island and installed a puppet government of 30 oligarchs or something like that, at least not officially. Okay. Michael, I want to ask one other thing, and then when folks can start queuing up for questions. Big picture question: if we don't have collective bargaining in the public sector, and just because this is open-ended enough, we can talk about education specifically. Like, do you have insight into healthy alternative models for a well-functioning personnel system in the absence of collective bargaining? What would you point to?
Well, I would just point to the fact that you can look at the states that don't have mandatory public sector bargaining for teachers, and there's a large research literature, despite what you may hear. You hear a lot of times a very sloppy kind of analysis where people will say, oh, look at states that have right-to-work laws, compare the performance on the National Assessment of Education Progress, the student testing. Well, it turns out a lot of those states are in the South. They have higher poverty rates, right? This is not something that would pass muster in a university. If you look at the actual research literature, though, the findings for what happens when you have that collective bargaining at the school district level is you either see a negative relationship, particularly if you look at the restrictiveness of the contracts. and student achievement. But even if you find null results, think about what that means for a minute. It costs more when you have public sector bargaining. So if the results are, you don't get better results, then what that's saying is you're paying for mediocrity. So I think one of the areas where, and maybe there would be a difference of opinion on this, but I'm more concerned, probably because of what we saw during COVID, I'm more concerned with the ability of teachers' unions to negotiate these super long contracts on the working conditions piece. Benefits are another big issue, although a lot of that goes to sort of, in some cases, guarantees in state constitutions on pensions. I know, like in Illinois, they tried to pass reforms, and the state Supreme Court said, no, these are guaranteed rights. I'm not as worried about the idea of negotiating salaries. It's suboptimal, but what's really a problem is when you know, and Washington, D.C. is a great example of this. So George Parker was the president of the teachers union here in Washington, D.C. when Michelle Rhee was appointed superintendent, and the district made tremendous strides academically. And after he left that position, he's been very open in saying that, look, in the old days when we had, you know, a school board that I could lean on politically, I could simply go down there and get them to block any reform ideas I didn't like that had to do with working conditions, or where we saw in COVID, MOUs being enacted, you know, with just ridiculous safety provisions that no one else in any other sector was getting to simply reopen schools. So I do think that the model forward, sort of maybe splitting the baby here, would be, you know, we don't have to totally run away from negotiating base wages, but we've really got to lean out these contracts.
Yeah, and I welcome if there's comments from others on this. A point on that exact distinction between compensation and working conditions is this seems to also track a classic concept in employment law, which is that someone becomes an agent becomes an employee of someone else if his work is subject to the direction and control. And that goes more to working conditions, because you can have contractors who are not employees who still get paid handsomely there. So there's arguably a distinction there. Okay, if there's not any other commentary from our panel now, love to turn it over to our audience for additional questions. Feel free to just queue up at the mics.
Thanks. This has been a terrific discussion, and I think that, you know, I love that it was wide-ranging on both history and the administrative state. I can't help but endorse the discussion about the Republican Guarantee Clause. At the same time, several of you mentioned the questions coming up this term on executive power, and if anything, the Republican Guarantee Clause is a reminder against royalism. And so the arguments that the Roberts Court has been making on executive power and removal rely on some of the arguments, especially this term, in amicus briefs, highlight a royalist argument that this is what kings did in English history. So, yeah, I know this is not exactly on, but you know, given that we're talking about the revival of the Republican Guarantee Clause, it strikes me that there is a contradiction in the way that clause is being used with the administrative state. Again, it's that the royalist arguments are being made that are not actually historically accurate, but it does seem like if you're going to revive the Republican Guarantee Clause, it would seem to be important to try and get that history correct.
I'll take that as a friendly request to do more research. Got it.
Go ahead.
Dr. Hartney, you referred to this, but if anyone on the panel wants to address, could you talk a little bit more about what the scope of associational rights are for the union? I mean, we're starting to see unions assert associational rights claims when they're challenged on things like opt-out windows or access to payroll deduction systems. You mentioned, you know, right to organize, right to advocacy, and maybe that's it. If we're talking about, Mr. Howard's suggested maybe putting limits on advocacy, and maybe Ilya, if you could chime in on how maybe the Supreme Court would sort through that from a First Amendment standpoint and where kind of the lines might be drawn.
Well, just quickly. On the exclusivity piece, it's interesting. that actually was litigated in a 1983 Supreme Court case arising out of Indiana, where basically it was, today you kind of roll your eyes a bit because who uses snail mail? You can just contact your teachers via email, but back then it was a really big deal to be able to get access to teacher mailboxes. And the funny thing was, the case that went all the way up to the Supreme Court was one in which you had an NEA affiliate in Indiana sue an AFT affiliate, and it was mad because it had lost the election for representation and it wanted to distribute its literature. And the court, this is a really important case because the court essentially held, and the language was brought back up by Justice Sotomayor. Interestingly, she made a comment. A few people who are really in the weeds on teachers' unions caught this. It was during the Friedrichs case. During oral arguments, she was trying to defend the right for agency fees by saying that the state of California had actually established the California Teachers Association. She wanted to argue that it was a quasi-governmental agency. And that language actually dates back to the Perry decision, where the court in that case, in defending the right of the school district to grant a single union a monopoly on all of those association rights, said that when, through exclusive representation, teachers or other public workers vote for a union, even if it's a slim victory, that in the case of education, that union becomes structurally a part of the school district, is in the Supreme Court case, which to me was just crazy, especially decades later when you start getting all these education reform advocacy groups. The Charter School Association in a state isn't part of the school district. It's just another stakeholder that wants to argue its point. So the Perry decision is really where it all starts, and I just think that what needs to be done, whether it's through some of the corruption points that have been made, like anything that's literally government handing over a subsidy that helps solve a collective action problem, they should either have to give that to everybody else in the district, or they should give it to no one.
I'll just add, because there was a query about what the court would do with these sorts of cases. Well, if they take one up, I'm confident they'll do the right thing. But it's getting them to take one of these cases, and that would require a showing that it's really important, not just some one rogue district somewhere, one rogue union, and they're not allowing Janus rights, or they're really weird thing going on in one place, but something that's national and important, and a circuit split would help as well.
So I'll interject here. I've got one good candidate for this. This will help with the discussion, I think. There's a case called Goldstein versus Professional Staff Union out of, right now it's at the Second Circuit. And it involves a union that has embraced the BDS movement. They've denounced Israel and called for sanctions and divestment. And meanwhile, they represent professors at CUNY. A handful of those professors, most of whom are Jewish, said that they shouldn't have to be represented by a union that ultimately hates their guts. Seems fair enough, but exclusive representation allows a union, you guys should be clear on this, not just to represent members, but to represent everyone in a particular bargaining unit. So there are some people who are coerced, a minority who are coerced into being represented by the union. And this is just one of the awful, examples of something that can happen when you force that kind of a relationship on someone. There is case law that would make it difficult to win on that case at the lower levels. So they, as expected, they lost their claims before the district court, and right now are at the Second Circuit making some claims about how perhaps U.S. Supreme Court law in this area can be distinguished from the situation that they're involved in.
So I'm Dave Tryon from the Buckeye Institute, and I see two issues to this whole problem. One is coming up with a correct and an effective theory, legal theory. Second is finding a plaintiff, a willing plaintiff. And so I see you would typically want to look for a board of education to assert some of these rights. And in my experience, boards of education are pretty timid, and they look to their lawyers to say, you know, can we do this? What should we do? And the lawyers are very conservative as opposed to being aggressive and going after the unions. They want to kind of, I'm going to have to negotiate with them again next year, 2 years from now, so they don't want to rock the boat too much. And so, and plus, just one quick experience that I had. We wanted to try something different in our negotiations. We wanted to post all our negotiations, and we were told, "Oh, that's bad. They'll file a grievance against us." So everybody's going, "Oh, we don't want to do that." I said, "Well, so what happens if they file a grievance against us? Do they throw us in jail?" No. They might just tell you to stop doing it if you lose. So, well, okay, let's do it. So you don't have very many folks that are that aggressive or that willing to take risks. So who would be the proper plaintiff, and do we need to first educate our potential plaintiffs?
Yep, this is the first issue that came to my mind when I was reading Philip Howard's book. What kind, would the governor of California sue the union to say that it's hampered his ability to perform his job? He wouldn't. He may be a good plaintiff, but he's not available. But a flip in a governorship on a purple state could be a potential plaintiff. There's someone, say a conservative who comes in and realizes that they're really unable to make any effective decisions based on a collective bargaining agreement, I think has a pretty strong claim. You could say that about school boards. You noted the problem correctly, though. If school board terms are staggered, you rarely have this influx of strong conservative talent that comes in all at the same time, ready to do war with the teachers union. It's rare, but it does happen. I think that's the plaintiff that you're looking for. Any other ideas?
First of all, thank you for representing a number of people who have come to us and said, I want to get out of unions. We really don't litigate in Ohio, so we appreciate
Thanks
Buckeye.
for bringing them to us.
Two things. I think you're right. The school boards have to be willing to go with a lawyer who's aggressive. We lost one of those issues, public bargaining in Lincoln County, Washington, because the state said the state law preempted the local decision to try to have open bargaining. Again, a reason not to litigate in Washington state. But I think in Ohio, if I understand it correctly, your Supreme Court stayed fairly conservative. So it would be good to have something along those lines. I'm not a huge fan of your unfair labor practices cases. We have a case just last week. The board voted 2-1 to pursue a charge for a union which got money for their classified employees, the school bus drivers, et cetera, where the union just gave the money coming out of COVID to the union and said, you guys figure it out. It's a small union. There are 17 employees. The union gave $888 to each of the people they thought were in a union and gave $0 to each of the people who they knew were not in a union. There's a duty of fair representation. That obviously doesn't make a whole lot of sense. But the fact that that clear violation of the DFR had one dissenting vote strikes me as your governors better start thinking about who's on your labor board. So if you're going to try to go through a DFR, I pay a little bit more attention, I think, to who's on a board, because that may not have gotten very far yet.
That's a good point.
I'm not an education lawyer, but I am a lawyer. But I am one of those angry parents, AKA domestic terrorist, who was awakened from my slumber in COVID, and along with other angry parents, we found each other and we formed a parent association. PTSA is useless; they're in bed with the unions, and so we now have. I'm in Fairfax County, which got its fair share of media coverage, rightly so. But my question is, in Virginia, in 2021, before Youngkin was elected, the General Assembly authorized collective bargaining for teachers' unions, which is the worst thing that could possibly have happened, but it tells you the dynamic, because the teacher unions already own the school boards in Northern Virginia, particularly in Fairfax County. So not surprisingly, earlier this year, Fairfax County School Board did their organizing resolution, and they're in the process of certification now and will be negotiating. My question is this: the idea of litigating on the back end and all these creative theories is wonderful, but what you said, Dr. Hartney, about worried about negotiating the benefits or the conditions, not so much about the pensions, and that's very worrisome, because what they did during COVID. I mean, if the union demands that they asserted during COVID in Fairfax County and probably nationwide had been adopted, schools would still not be open. That was how aggressive that they were. So what can we as parent advocates do, if anything, during that process when we know the board and the unions are negotiating and when those agreements come to the board? Now, we do have elections this year. I think we might get one independent out of the 12 seats, but the good news is 8 of the 12 seats are open because all those members know they failed, so we might even get 2 out of the 12. So what can we do on the front end?
Well, one thing I'd say is there's a great advocacy organization, I think it's called Middle Ground in Virginia, that's doing good work in school board electioneering to try to get parent-friendly candidates elected. They probably won't have as much success in a place like where you're from, but the good news is that, as far as I understand it, maybe some of the attorneys can chime in on this, but the public sector bargaining law that was passed in Virginia is a permissive one. So in theory, it could get, well, that means 2 things. One, at the school district level, if you do turn over a board, there's no legal obligation for them to bargain with the teachers. They're doing it because the board is deciding they want to, different from a California or a Washington. And the other thing is, of course, I'm a big fan of, although I know there are divisions among people who are critical of teachers' unions, about sunshine in bargaining practices, about whether there should be transparency. Folks were a little, I mean, it just sounds good, right? Like the idea is like, shouldn't someone be in there? I've often thought that one reform is requiring another stakeholder, a parents group, a taxpayer person, to be at the bargaining table. But even if you didn't do that, just opening it up to sunlight, the unions sometimes actually seem to favor that, and I think it's because they think they can play the PR game really well and plead poverty to the citizens and make them think that the district is shortchanging them. But I do think that's another strategy that should be explored, is just opening up this stuff. We know recent research paper came out last week that a lot of the MOUs that were signed during COVID, a lot of those provisions, there were no givebacks. I mean, obviously, people went back to school, but a lot of the sort of things that they agreed to during COVID are still in place in those bargaining agreements. And without any sunshine, they're likely to stay there.
Thank you.
You know, Virginia also is a unique opportunity because Professor Hartney's right. It's a law that looks a little bit different. They didn't actually pass a Public Employee Relations Act the way that some other states have done. Instead, it's a local decision, not only to unionize, but under what terms. So in any given school district, ship has sailed in Fairfax, but in any other school district, you could actually limit the scope of collective bargaining. Even as you invite the union in, you say, we're only going to bargain over wages or benefits, and you could even say wages are capped at X%.
All right. If you all can please join me in thanking our panelists.
What do you think about using stone?
Thank you again to our panelists and our moderator for sharing your expertise with us this morning. Next up, please join us right outside in the Crystal Foyer, where Philip Howard will be signing copies of his new book, Not Accountable. And at 11:45, we'll reconvene in the Georgetown